Welcome to Wells Fargo Home Mortgage Customer Care and Recovery Group. This call may be monitored and recorded. Welcome to Wells Fargo Home Mortgage Customer Care and Recovery Group. This call may be monitored and recorded. To assist in routing your call, please select from one of the following options. If you know your party's extension, please press 1. If you are, please enter the extension now or remain.
Thank you for calling Wells Fargo Executive Office. This is Jordan. This call may be monitored or recorded. Who am I speaking with?
Hello, Jordan. My name is Joseph Powers, and I'm returning your phone call in response to some certified letters that I sent to Wells Fargo. You should know as well that this call is being recorded for documentation purposes.
Okay, I can consent to that, Mr. Powers. Thank you for returning my call. Give me just a moment to get back to the request here. Okay, so just wanted to attempt to let you know that we did receive the inquiry, and I will be researching and responding to you. As far as the due date, I do have until the 17th to compile all the information and provide that to you, Mr. Powers. So I will be giving you another call and sending everything in writing for you as well.
Okay.
And just to confirm, we do have the address. Let me just make sure.
The second address, that is East O'Galley. That's the easiest way to get a hold of me in the proper way.
Okay. Okay, perfect. And okay, perfect. All right. Well, I will follow up with you once again once I have everything for you, okay?
Is that all, or I have a statement I'd like to make?
That's fine. Yes, go ahead.
It's rather lengthy. You'll have to bear with me. First, may I have your full name and your title with the bank?
Jordan, J-O-R, and I'm an escalations representative.
Okay. Jordan G., escalations representative with Wells Fargo. I acknowledge that you're speaking in your official capacity. However, I do not accept any contractual obligations unless explicitly stated between us, agreed upon, and signed in writing. And I fully reserve all my rights regarding the scope of this interaction. Do you understand that?
Yes, sir.
Thank you. Before we proceed, let me clarify that your phone calls, nor this phone call, constitute an official response under the terms of my letter of intent, which requires a response within 20 days. You've already acknowledged that that form of response will be coming to the 274 East. So I just want to make it crystal clear that this call does not waive those deadlines or obligations, and if my written response is not received within the required time frame, it will be taken as evidence of concealment and bad faith. My statement that I have to make contain. Go ahead.
I just said okay.
Oh, I'm sorry. My statement that I have to make is somewhat lengthy, and some parts contain some questions which may require a yes or no answer. Please do not interrupt the statement other than to answer a direct question to you with yes or no. And I'll let you know when I've completed my statement, and then if you wish to make a statement on your behalf or on Wells Fargo, you may do so. The following is not an exhaustive list of violations committed against me. I expressly reserve all rights to assert additional claims and causes of action in future litigation as necessary. Number 1, Wells Fargo status as a foreign entity. Jordan G., you work for Wells Fargo's executive offices, correct?
Yes, sir.
Thank you. Then you may or may not be aware that Wells Fargo operates as a foreign banking organization under 12 U.S.C. subsection 1841, and as such, it is restricted in the financial activities that it may conduct with United States citizens. Under 12 U.S.C. subsection 1843, a bank holding company like Wells Fargo is not authorized to transact with the general public, meaning that any transactions conducted with me need to be fully disclosed, as I'm not a financial institution. The promissory note and securitization I executed on 4/26/2011 in the amount of $265,000. Wells Fargo monetized that promissory note and securitized it, yet continued to collect payments from me for over 7 years, violating multiple federal laws. I have yet to receive my original promissory note back, which raises significant legal questions. The followings are just examples of some of those questions. Does Wells Fargo still possess my promissory note, or has it been sold, traded, or pledged? If it was sold, when, to whom, and for how much? Did Wells Fargo receive third-party payments on this note that were not credited to my account? Failure to disclose this information constitutes unjust enrichment and deceptive trade practices. Under 18 U.S.C. subsection 1005, Wells Fargo executives and employees can be held personally responsible for false banking entries and financial concealment. Under 12 USC subsection 503, Wells Fargo and its directors may be liable for personal profiting from the unauthorized securitization of my note. My forensic accounting records show that my ledger is complete, and I have a forensic accountant at my disposal who will attest to Wells Fargo's securitization processes. I have also attached a perfected allonge to my promissory note, which means that Wells Fargo no longer has the lawful right to enforce or claim ownership of it unless full disclosure is provided. Upon belief in information pertaining to federal law, a cash collateral account exists or did exist in connection to my note, which means that a legal set-off should have been applied to the discharge for the obligation. If Wells Fargo failed to apply such an offset, that's further evidence of fraudulent concealment. Under 12 USC subsection 84, Wells Fargo may have violated lending limits, and under 12 USC subsection 375A, any undisclosed third-party payoffs or insurance proceeds are further grounds for legal action. I was entitled to receive the interest on the coupon payments I remitted each month. These payments constitute negotiable instruments, and I am legally able to collect interest pursuant to the indenture agreement Wells Fargo has on file with the SEC. Furthermore, under actions for injuries to personal or real property, actions for the detention or conversion of personal property, and civil actions based on any alleged violation of any federal or state statute creating a monetary liability for personal services rendered or liquidated damage or other recovery, therefore, when no other time of limitation is fixed by the statute creating such a liability. Since I only recently discovered Wells Fargo's fraudulent concealment of the securitization of my promissory note, the failure to disclose third-party payments, and unjust enrichment through continued collections after settlement, the statute of limitations has only just begun to run. Additionally, I retain a private right of action under 12 USC subsection 1978, which allows private parties to challenge the legality of financial transactions and banking practices. 18 USC subsection 1005 holds bank officers accountable for false bank entries and fraudulent transactions. 18 USC subsection 1640 TILA provides a private right of action against creditors who fail to disclose material financial transactions. I expressly reserve my right to take private legal action against Wells Fargo and any responsible parties for fraud, unjust enrichment, deceptive trade practices, and failure to disclose material financial information. This includes the right to seek disgorgement of profits, statutory damages, treble damages, and injunctive relief in a court of law. Therefore, should this instant matter be brought before a federal court, I will seek the following relief: disgorgement of unlawfully obtained funds and treble damages for unjust enrichment under applicable federal statutes; declaratory relief confirming that Wells Fargo has engaged in deceptive trade practices, fraudulent concealment, and unjust enrichment in violations of federal banking laws; injunctive relief to prevent Wells Fargo from continuing to engage in fraudulent financial transactions, securitization concealment, and deceptive lending practices; punitive damages to deter future misconduct and penalize Wells Fargo for its reckless disregard for financial integrity and consumer rights; statutory damages under 12 USC subsection 503, 18 USC subsection 1005, and 15 USC subsection 1640, for banks' violations of federal banking, fraud, and consumer protection laws. Attorney's fees and litigation costs is allowed under federal law to compensate for the burden of pursuing legal action against a financial institution engaged in willful misconduct. Personal damages against individual officers, directors, and employees of Wells Fargo who were or are directly involved in the fraudulent financial transactions, concealment of material facts, and unjust enrichment at my expense. These individuals may be held personally liable under 12 USC subsection 503, liability of bank officers and directors; 18 USC subsection 1005, false bank entries; 18 USC subsection number 22, 12 CFR subsection 12 CFR subsection 211.10, permissive activities abroad. Activities usual in connection with banking. The board has determined that the following activities are usual in connection with the transaction of banking or other financial operations abroad outside the United States. Commercial and other banking. Financing, including commercial financing, consumer financing, mortgage banking, and factoring. 12 USC subsections 1861 through 1865. The Bank Service Act forbids the acceptance of a deposit from an American citizen, and jurisdictional operations are restricted to 12 USC subsection 1843 outside the United States. Number 24, the published regulation series 12 CFR subsection 211 foreign banking lists the only permissible lien on real estate restricted to the extension of credit for foreign real estate. Number 25, 12 USC subsection 378 forbids national banking associations to be associated with any investment companies in regards to any asset located in the United States, and neither are permitted to accept a deposit from an American citizen. Number 26, 12 USC subsection 29 does not permit national banking associations to own real property other than a bank building or property mortgaged by an affiliate as a payment in regards to a debt owed to a member bank. Number 27, 12 USC subsection 615 restricts the business of banking inclusive of deposit taking to outside the United States. Number 28, 12 CFR subsection 250.143 section D restricts national banks to foreign branches outside the United States. Number 29, 12 USC subsection 3631 refers to national banks as corporations. False representations as to the liability of United States for acts of the corporation can impose a $10,000 fine and imprisonment for not more than 5 years for even inferring that Wells Fargo has any connection to the United States. Number 30, National Bank versus Matthews, U.S., January 1, 1878, 98 U.S. 621, Mr. Justice Miller dissenting. Quote, I am of the opinion that the National Banking Act makes void every mortgage or other conveyance of land as a security for real money loaned by the bank at the time of the transaction to whomsoever the conveyance may be made, and that the bank is forbidden to accept such a security, and it is void in its hands, end quote. 31. I am not a covered person under the Private Securities Litigation Act, by definition a member bank subject to the interbank liabilities listed in 12 CFR subsection 206. Excuse me. Number 32, to provide for the establishment of Federal Savings and Loan Associations, the HOLA Act, by its subsection 3, 48 Statute 129, repealed subsection 4D of the Federal Home Loan Bank Act, 47 Statute 727, which had authorized federal home loan banks to make loans directly to homeowners. Number 33, CFR 12 CFR subsection 204.8, International Banking Facilities. Time deposit, or IBF time deposit, represents funds deposited to the credit of a non-United States resident or a foreign branch office, subsidiary, affiliate, or other foreign establishment that deposits received by the international banking facilities may be used only to support the depositor's operations outside the United States as specified in subsection 204.8A2II, and that extensions of credit by the IBFs may be used only to finance operations outside the United States as specified in subsection 204.8A3VI. Number 34, 12 USC subsection 375A, loans to executive officers of banks, an extension of credit which the bank is authorized to make under this section. Mortgage loans. A member bank may make a loan to any executive officer of the bank if at that time the loan is made, it is secured by a first lien on a dwelling which is expected after the making of the loan to be owned by the officer and used by him at his residence, and no other loan by the bank to the officer under authority of this paragraph is outstanding. Educational loans. A member bank may make extensions of credit to any executive officer of the bank to finance the education of the children of that officer. Number 35, Title 12 USC subsection 501A, forfeiture of franchise of national banks for failure to comply with provisions of this chapter. Should any national banking association in the United States now organized fail within 1 year after December 23, 1913 to become a member bank, or fail to comply with any of the provisions of this chapter applicable thereto, all of the rights, privileges, and franchises of such an association granted to it under the National Bank Act, 12 U.S.C. 21 et sec, or under the provisions of this chapter, shall thereby be forfeited. Number 36, December 23, 1913, Chapter 6, subsection 25A, par, formerly subsection 25A, as added December 24, 1919, Chapter 18, 41 Statute 378. 12 CFR, subsection 211.1, authority, purpose, and scope. Corporations organized under this section 25A of the FRA, 12 USC subsection 611 through 631, EDGE corporations. Number 37, the International Operations Regulation, 12 CFR subsection 20, an EDGE corporation is a foreign banking corporation. 12 CFR subsection 4.12, Title 12, Banks and Banking, the International Operations Regulation, Part 20 of this chapter, reports of international operations, requires that a national bank notify the comptroller before the establishment of a foreign branch or other controlled international banking offices and before the acquisition of a direct or indirect controlling interest in a foreign bank or in certain other corporations. For the purposes of this subparagraph, a foreign bank corporation is any bank or corporation chartered or incorporated under the laws of the United States or any state, thereof including any corporation organized under 12 USC subsection 611 to 632, which is principally engaged in international or foreign banking or financing or banking in a dependency or insular possession of the United States, directly or through the agency ownership or control of local institutions in foreign countries or in such dependencies or insular possessions, or any corporation or other association organized under the laws of a foreign country or a dependency or insular possession of the United States, which is principally engaged in commercial banking. Number 38, an EDGE Act corporation, section 25A of the FRA, 12 USC, subsection 611 through 631, is a financial institution. Public Law 97-290, section 101. This title may be cited as the Export Trading Company Act of 1982. It is the purpose of this act to increase United States exports of products and services by permitting bank holding companies, bankers' banks, and EDGE Act corporations and agreement corporations that are subsidiaries of bank holding companies to invest only in export trading companies by reducing restrictions on trade financing provided by financial institutions and by modifying the application of the antitrust laws to certain export trade. Number 39, Title 12 CFR subsection 28, section 51 states that international loan means a loan made to a foreign government or to an individual or corporation or other entity not a citizen of, resident in, or organized or incorporated in the United States. Number 40, Public Law 89-485, Section 6H, secured by a cash collateral deposit of 100% of the amount of credit extended. Number 41, Section 22 of the 1913 Federal Reserve Act restricts all financial transactions to member bank transactions with other member banks. Section 22 of the 1913 Federal Reserve Act was amended in 1933 with the enactment of Section 23, 12 USC subsection 371, permitting financial transactions with banking affiliates. 12 USC subsection 371 is the authority for real estate loans outside the United States. As of 1918, Section 19B of the 1913 Federal Reserve Act prohibits the acceptance of any type of domestic deposit or transaction account deposit subject to withdrawals by checks by any financial instrument in the United States. Title 12 U.S.C. subsection 615 is the keystone of permissive activity of the chartered national banking associations, prohibits the acceptance of a deposit from an American citizen. And I'll add a special note here that I've held checking and savings accounts with Wells Fargo as well as this promissory note for this mortgage for years, and Wells Fargo has accepted those deposits unconditionally. The 1919 amendment to the 1913 Federal Reserve Act, the EDGE Act, permitted corporations restricted to import-export financing in the international financial markets and prohibited the acceptance of a deposit from an American citizen. Bank holding companies restricted to pooling funds for import-export financing are prohibited from the acceptance of a deposit from an American citizen. The 1932 enactment of the Homeowners Loan Act, amended in 1933, prohibited the acceptance of a deposit from an American citizen. 12 U.S.C. number 3, subsection 378, Dealers in Securities Act, enacted in 1933, does not permit any acceptance of a deposit from an American citizen. Title 12 U.S.C. subsection 632, enacted in 1933, only allows litigation of any claim of the permissive foreign banking provisions to a federal district court, which excludes any litigation in a state court. The only enforceable loan, lending of money, contract has to occur at a branch outside the United States, 12 U.S.C. subsection 615. Loan production offices restricted to member bank transactions must be located where the bank is permitted to establish a branch and are not allowed to be open to the general public. Consequently, any or all contrived notions of permissiveness of any loan or loan servicer concerning an American citizen would constitute a criminal charge of banking fraud, 18 U.S.C. subsection 1005 per 12 U.S.C. subsection 503. No investment in private residential real property in the United States, 12 CFR 1500. No deposit taking from an American citizen, 12 U.S.C. 378, 12 U.S.C. 1862, 12 U.S.C. 3102. No foreclosure of private residential real property in the United States, 12 CFR 225.28. No liens on real property in the United States, 12 CFR 211.4. No banking in the United States, Public Law 89-485, Section 3. No real estate loans in the United States, Public Law 89-485, Section 6H, 12 U.S.C. 29, 12 U.S.C. 375B. No branching in the United States, 12 U.S.C. 36. Extensions of credit must be secured by a collateral deposit of 100% in cash, 12 CFR 215. No home loans to individuals, HOLA of 1933. No securities or hedge fund investment in the United States, 12 U.S.C. 1850. No credit intermediaries in the United States, 12 CFR 225.28. No bank holding companies in the United States, 12 U.S.C. 1843. No savings and loan associations in the United States, 12 CFR 225.28. No student loans from any industrial loan company, Sallie Mae, Freddie Mac, FHA, 12 CFR 225.28. No housing loans in the United States, 12 U.S.C. 1432B. No evictions from private residential real property in the United States under HUD and Overseas Private Investment Corporation, 22 U.S.C. 2183. No state court proceedings, 12 U.S.C. 632. Jordan, in closing, I'll be following up with written confirmation that this call does not constitute an official response and that the 20-day deadline still stands. If I do not receive full compliance within that time, I will be filing complaints with the Office of the Comptroller of the Currency, federal, state, and county, the Federal Reserve Board, because this is a banking policy issue, the SEC. If my promissory note was bundled into an MBS, then Wells Fargo has an obligation under SEC Rule 424B to disclose those transactions. The Financial Crimes Enforcement Network, I'll file a suspicious activity report. The U.S. Department of Justice, I'll request a formal investigation into the financial fraud, bank misconduct, and violations of federal banking laws committed by Wells Fargo on myself and millions of other United States citizens. This constitutes a RICO violation. The Internal Revenue Service, I'll file a Form 3949-A and request an audit of Wells Fargo's MBS transactions. The State Attorney General, just because I can involve the state court for fraud committed at the state level. And as well, I'll be pursuing federal litigation. Additionally, any further failure to disclose any information or respond in good faith could trigger criminal referrals under 18 U.S.C. subsection 1005 and 18 U.S.C. subsection 1951 for financial fraud and extortion under color of law. If I do not receive a full forensic accounting of my mortgage transactions, including all endorsements, assignments, and third-party payments, or a satisfactory response confirming the codified law in my letter of intent and this recorded conversation, and Wells Fargo's intentions to correct their violations of federal law and the harm they have caused me, I will be obligated to inform the United States that an enemy of the state is conducting business within the United States with United States citizens, and then I will be required by law to refer this to a federal court as a case of banking fraud, unjust enrichment, deceptive trade practices, and RICO violations. Do you understand?
Yes, sir.
I finished my statement, Jordan G. You may make a statement if you so choose to do so.
Thank you. I took down any information here, so there's nothing further that I need at this point.
Okay, I'll be looking for your communication.
Thank you.
Thank you.
Bye-bye.
All right, it's processing the call. You kill it.